Hello, and welcome to Afford Law. Today, we're going to be discussing the crime of intimidation of a witness, juror, court official, or law enforcement officer, simply referred to as intimidation of a witness. There are three elements that must be shown beyond a reasonable doubt in order to find you guilty of this crime. Those elements are that there was something that you did willfully to another person who was involved in a court proceeding, and you did so with either the specific intent or with a reckless disregard of interfering with that particular proceeding before the court. Now, the intent to obstruct a legal proceeding or investigation is at the key, obviously, of any of these cases. The first element, let's break it all down. The first element is that you willfully did something. Now, that willful something has to be either actions or words that either threatened, attempted, or caused physical harm, attempted or caused economic harm or emotional harm, offered something of value. So you could have bribed a person to influence the outcome of their testimony, that you misled them, intimidated them, or otherwise harassed them. If the intimidation is the allegation, keep in mind that an attempt to intimidate a witness does not have to be successful in order for you to be found guilty. That is to say that if your threatening manner or whatever doesn't influence that person, you could still be found guilty. As an example, there's a case in Massachusetts where a witness recanted her statement. That just means that she changed her statement to something else. So originally she said that the defendant had assaulted her. When she got on the stand, she said that didn't take place, and she changed her story. The defendant had called and made threatening phone calls to the defendant, but the defendant never, to the witness rather, but the witness never received those phone calls prior to her testimony. So therefore, the attempted intimidation was not successful because she never got the phone calls before she testified. However, that person was found guilty of intimidation of a witness because they intended to do so. Keep in mind also that the alleged victim does not actually have to be placed in fear as a result of your threatening behavior or threatening words. So for instance, if I threaten you with something, if I say I'm going to harm you in some way, but you're not afraid of me, that can still be considered intimidation of a witness. Again, because my state of mind is I want to influence how you're going to act during the course of this criminal or civil proceeding before the court. There's a case in Massachusetts that's instructive on this topic. Inside the courthouse, there were a number of people that were milling about waiting for a particular witness to be called in a case. While this was happening, somebody in the group that was associated with the case made photographic actions as if they were taking the picture of the witness, as if to say, if you testify, I know who you are, we can reach out, we can retaliate against you. That was considered intimidation of a witness. Another case in Massachusetts involving photography, as a matter of fact, is there was a case where a witness's family was photographed near their home on the day that the witness was supposed to testify. Obviously, the person was trying to get to the witness through their family, through a subtle or not so subtle gesture toward them, and trying to influence again their participation in the court proceeding. The second element is that these actions or words have to be conveyed and addressed to another person, and that other person has to be involved somehow with a court proceeding. So typically we see this with witnesses, with someone with information about a crime, somebody working in the justice system, so a probation officer or a court clerk or a judge, for instance, somebody who is attending a court proceeding, or somebody with information about a court order or a violation of that court order, or a family member of one of those persons that we just discussed. So those are the first two elements, that you did something willfully to another person, and the third one is that with the purpose to obstruct or interfere or otherwise get in the way of the court proceeding. So you could be an allegation of that you impeded that investigation or that court proceeding, that you prevented it or delayed it, or otherwise interfered, or that you threatened to retaliate against the person who was participating in that court proceeding or already had participated in that court proceeding. This third element about the type of action breaks down into two subcategories. One is specific intent, and the other one is a reckless disregard. So with specific intent branch of that subcategory, the purpose of the behavior, so the very purpose of you acting or saying the things that you did were specifically to interfere or otherwise get in the way of the court proceeding or the investigation. So it goes to the state of mind of the defendant, of you in this case, that you wanted to get in the way and alter the outcome of the proceeding. Now, it's very difficult, obviously, or impossible, for people to know what is in the mind of another person. Jurors, however, are instructed that they should look to the actions, words, and surrounding circumstances in everything involved in the case, in order to try to determine what the state of mind of the person that was testifying, a state of mind of the alleged intimidator was. Now, the reckless disregard theory, reckless disregard is something that goes well beyond mere negligence. Negligence is just something that almost it was an accident or the outcome was unintended. Reckless disregard is the standard is that you knew or should have known what the outcome of your actions or words were. So it's not that you specifically said, I want to get in the way of this court proceeding, but in looking at your actions, clearly that was going to be the result. Now, it's what they call an objective standard. So that doesn't mean the Commonwealth has to prove what exactly was your thinking. It's an objective standard, which means the jury is instructed to determine what would a reasonable person think in that situation. So what would a reasonable person think would be the outcome of those specific actions and words and so forth. So you can't rely on the defense of, oh, I didn't know what was going on, because the jury was going to be instructed that if a reasonable person would not have acted that way, then you should not have acted that way, and you could be found guilty on this charge. We see this charge most commonly, and it doesn't seem to make sense to people who are charged with it, and at first it looks like it shouldn't even be charged. We most often see this charge where a person is accused of taking a phone away from another person to prevent them from calling the police. We see these very commonly in domestic violence cases, for instance, where a person is charged with domestic violence in Massachusetts. It's called assault and battery on a family or a household member, where they're charged with the actual assault and battery, as well as an intimidation of a witness charge, because the allegations are not only that they somehow physically touched or harmed the other person, they took the phone away from that person in order for them not to call the police, to call for help. It's a very serious charge. It seems odd to me that if someone's charged with harming another person and taking their phone away, the actual taking their phone away, which is the intimidation of a witness, is a felony. And the domestic violence charge is a misdemeanor. Obviously, any criminal charge is a serious matter, but the court takes more seriously, or the legislature has decided that it's more serious, that an offense against the judicial proceeding itself is a higher crime, if you will. So that's intimidation of a witness, sort of in a nutshell, in Massachusetts. If you have any questions, please feel free to call us, and please make sure you visit us at affordlaw.org, where you can see if you qualify for our reduced rates, because all of our fees are on a sliding scale. we can help.